this afternoon. Hope you all had a wonderful day. Now, I want to get back on Aubrey Trail today, and I also want to talk about something else. Oh, shoot, my phone. Hang on just a second. I forgot I needed it. Oh, boy. Hang on. Plug it in here. Let's see. All right. Now, here we go. Get this right here. I'm going to have to plug my phone in. Oh, Lord. Yeah, this will be all right. Yeah, I didn't charge it. Anyway, it's a whole big deal about these chargers. So I want to get back on Aubrey Trail. The one thing I want to talk about is serial killers, witches, vampires, and zombie slayers. Here's the thing about this. Letitia Stout, okay, wasn't the first one. Aubrey Trail wasn't the first one to claim that they were part of the witches' coven, or that they were vampires, or that they were zombies. That they were the reason that was the reason why they were taking people's lives or whatever. It had something to do with that. They're not the first one. They're probably not going to be the last ones either. But I did find some interesting information. Let me pull this back up over here because it's not on my laptop. It's over here on my phone. I was just searching around, going, okay, what's the deal here, right? I'll get off of there. Turn off that. Okay. Let's talk about this person. You may or may not have heard of him before, but you may have. I'm not sure. Okay, if the weather has changed over here now, it's kind of like muggy and yeah, but okay. Here we go. So let's talk about Roderick Justin Rod Ferrell. He was born March 28th of 1980, and he's an American murderer, or unaliver, as you would say, as a cult leader who was a member of a loose-knit gang of teenagers from Murray, Kentucky, okay, known as the Vampire Clan. Right, okay. Ferrell claimed, listen to this carefully, because Nick and other people have claimed that they were a 500-year-old vampire. Nick did it, Aubrey Trail did it, Justin Roderick Ferrell did it, okay? So, Ferrell claimed to be this 500-year-old vampire named Visaggio, a character he created for himself after becoming obsessed with the role-playing game Vampire the Masquerade. It was his mother, Sandra Gibson, who first introduced the game to Rod. In 1998, Ferrell pleaded guilty to the double slayings of a couple from Eustis, Florida, becoming the youngest person on death row in Florida at that time. Originally sentenced to death, Ferrell's penalty has since been reduced to life in prison. In 2023, he married somebody named Stephanie. Okay. Now, let's look at this legal period. On February the 12th, 1998, the 18-year-old Ferrell pleaded guilty to the murders, claiming the others traveling with him were innocent except Scott Anderson. Oh, Lord. Hang on. My dogs are barking because every time UPS, FedEx, shh. Hey. They'll leave. Hey. Jack. Oh, boy. Poor Jack. He just can't help himself. He's a dog. He's a watchdog. What do you want? All right. Come on, Jack. It's okay. Anyway. Don't make me shut the window, baby. Come on. All right, let's go back to it. I'm so sorry, Okay, so he says everybody else was innocent except somebody named Scott Anderson, who was simply an accessory. Ferrell pled guilty to 2 counts of felony murder. His attorney tried to argue that he was insane. He was diagnosed with mental disorders, including schizopath personality disorder and Asperger's syndrome. The University of Florida further attested that Rod sometimes witnessed spiritual things such as angels and demons. Oh boy, we have another Chad Daybell on our hands. We might have. Judge Jerry T. Lockett sentenced Ferrell to death. Charity Kesey was convicted of 2 counts of third-degree murder, robbery with a gun or deadly weapon, and burglary armed with weapon or explosives. She was sentenced to 10.5 years in state prison, and Dana Cooper was convicted of those charges as well, but was given a 17.5-year prison sentence. Okay. Anderson was convicted of the same charges as Ferrell and was sentenced to life in prison. For 2 years, Ferrell had held the record as the youngest inmate on death row. This changed in November of 2000, when the Florida Supreme Court reduced his sentence to life in prison. Kesey was released from prison in March of 2006 and Cooper was released from prison in October of 2011. In January of 2013, an appellate court dismissed attempts by Ferrell and Howard Scott Anderson to get new sentencing hearings. However, in December of 2018, Howard Scott Anderson was resentenced by Circuit Judge John Briggs to a 40-year prison sentence. Anderson was given credit for the 22 years he had already served, making him first eligible for release in 2031. So his first parole hearing is going to be in 2031. Okay. Ruth Windiford's relatives attended Anderson's resentencing hearing and did not oppose his early release. Speaking with the Daily Commercial, they said they are more concerned about Ferrell, who was scheduled for his own resentencing hearing in July of 2019. Ferrell's hearing was subsequently rescheduled for November 18th and then again in April of 2020. When the sentencing judge upheld his life without parole and deemed him irreparably corrupt, because he is, I'm pretty sure, Anderson is currently incarcerated in the Calhoun Correctional Institute, while Ferrell is in the Northwest Florida Reception Center Annex. Okay, so there you go. That was one as well. Now, there's an interesting situation here. Now, let me go back to the other one. Hang on just a second. Oh, boy, I came up with all kinds of info this morning. All right. Now, shh, don't do that. I wish you would stop trying to do that. Look at my bookmarks. Oh, boy. Here's another one. All right. Have you ever heard of Tracy Arrell Wigington? Born August 4th, 1965. Known as the lesbian vampire killer. We got. She's an Australian murderer who achieved notoriety for killing Edward Badlock in 1989, supposedly to drink his blood. This was described as one of the most brutal and bizarre crimes Australia has ever seen. Wigington was sentenced to life imprisonment in 1991. Now here's something strange. She was sentenced to life imprisonment in 1991, but she was paroled in 2012. So Australia has an extremely different set of judicial rules than we do, huh? All right, hang on a second. Let me drink my Coke. Ooh, hot and thirsty. Now, Wigington was the only one of the four co-accused who pled guilty to the charge of murder. Therefore, there was no trial for her, and a few details were disclosed to the court as to why this incident occurred by Wigington. Pachowski, Jervis, and Wolf stated that Wigington had claimed to have vampiric tendencies. They said that the reason for their murder was to enable to the drinking of the man's blood. During the trial, Wigington said to the media, "It's hard to be famous, isn't it?" It is hard to be famous, and I'm sure you found a reason, right? You found a way. Claim you're a vampire. Claim you're a 5-year-old vampire. Claim that you're a witch, part of a witch's coven. All kinds of things. Claim that you have portals. Claim that you have these vampires visiting you in your cell. They will all make you very famous, right? Okay. A legend in my mind. In 1991, Wigington was sentenced to life imprisonment by Supreme Court of Queensland with a minimum of 13 years. Pachowski was also convicted of murder, and Jervis was of manslaughter. Bowe was acquitted. Okay. So, there's something else. Let me see. Is this another one? Hang on a second. I had a whole bunch of these. Well, let me go back. So, there has been more than 1, 2, 3, or 4 of these people, 5, that claim to be a vampire or part of a witch's coven or a zombie slayer. Okay? So, and there will be more. This is not the end of this. You will see that there are people who will use this over and over and over. So hang on a second. Okay, let me get this pulled up. Now this is the Supreme Court brief from Rodney Ferrell. Okay, now, sorry, so I can get it to, I can read it better. Okay, hang on a second there. So, this is the statement of his case. I love to read the briefs because there's a lot of information in them that we would not otherwise have. On November 25th of 1996, the bodies of Richard Wendorf and Naomi Queen were discovered in their Eustis, Florida home. The defendant, Roderick Ferrell, was developed as a suspect, and on November 27th, 1996, a warrant was issued for his arrest. On December 17th of 1996, Lake County, Florida grand jury returned an indictment which, inter alia, charged Farrell with 2 counts of first-degree murder in the deaths of Richard Wendorf and Naoma Queen. I'm sorry, I think it's Noma. It's Naoma. Farrell entered a written plea of not guilty on December 17, 1996, and filed notice of intent to participate in discovery. Farrell filed a written waiver of speedy trial on January the 23rd of 1997. The case proceeded through the pretrial stages, and on February the 2nd, 1998, jury selection had begun. A jury was duly impaneled, impaneled, not impaled. No, we don't want to impale. We don't want to impale our jury. A jury was impaneled, and on February the 5th, 1998, Farrell decided to enter a plea of guilty to the offense charged in the indictment. The court accepted this plea and adjudicated Farrell guilty. The jury was made aware of the change of plea and was discharged until the penalty phase of Farrell's trial began. So, then it goes to, over here. The penalty phase of Farrell's trial began as scheduled on February the 12th, 1998. On February the 23rd, 1998, the jury recommended that Farrell be sentenced to death for both the murders of a vote of 12-0, so it was unanimous, right? On February the 27th, 1998, the court followed the jury's recommendation and imposed 2 sentences of death on the defendant. In sentencing Farrell to death, the circuit court found as aggravating circumstances that Farrell had previously been convicted of another capital felony. Hear me out, another capital felony. So this man had already committed murder once before and had been to prison, I guess, and been released back out into the public to take somebody else's life. Unbelievable, isn't it? Unbelievable. You know what I didn't do? I didn't put my little, I hope y'all can hear me okay. I didn't put on my little microphone. There we go. Let's put our microphone on. I hope I don't have to go back through that whole thing again. Oh, how stupid. Okay. I wonder if there's some way I can hear what you heard. Hang on just a second, guys. Stay right there. Let me do something right here. Let me go over here. Just a minute. Hang on, guys. So sorry. Let me make sure I got myself. It's just crazy, isn't it? Okay. Hang on, guys. Okay. I think you can hear me. Okay. I wanted to make sure. Hang on. Okay, yeah, you can hear it. Okay, great. Because I was afraid you wasn't able to hear it, but since I did not have my microphone, I was like, oh no. Okay, there we go. Okay, let me get back to the brief we're reading up here. It's very interesting information. Turn this sideways. Okay. So, as I was saying, he had already had 1 capital guilty before and was out to kill another person. All right, the aggravating circumstances. All right, I have to go back to where we were before I had to go make sure that you could even hear me. So, he was committed. Okay. Okay, hang on a second. Just let me go find this spot right here. Boy, it makes me mad at myself. So, on the penalty phase of Farrell's trial, as it began scheduled, on February the 23rd, the jury recommended that Farrell be sentenced to death for both murders by a vote of 12-0. So, it was unanimous. I think I said that already. Go back. On February the 27th, the court followed by the jury's recommendations and imposed 2 sentences of death on the defendant. In sentencing Farrell to death, the circuit court found as aggravating circumstances that Farrell had previously been convicted of another capital felony, that the murders were committed during the course of hang on a second. I might be wrong because I didn't read ahead of time. I'm just looking at it now. Maybe he was not out. Maybe this is part of the same charge. Let me see. We might have to correct ourselves here, but that's okay too. So, that the murders were committed during the course of an enumerated felony of burglary or robbery, that the murder of Naoma Queen was especially heinous, atrocious, or cruel, and that the murders were committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Okay, so I was wrong. He was not out from some previous murder. It was just aggravated by the particularly heinous, cold, and atrocious manner in which he took Naomi's life. Okay, good. Glad I corrected myself. I was going to be mad because I'm like, again, because it happens quite frequently. These people are let out of prison and they go out and just do the same thing again. All right? Okay. But the murder, okay, so we've talked about that for a second. Without any pretense of legal justification. The trial court considered and found various statutory and non-statutory mitigators, and the conclusion of the weighing process found that the aggravation outweighed the mitigation. Farrell filed a motion for a new trial on March 9, 1998. The motion was denied on May 4th of 1998. Okay. Notice of an appeal was given on May 22nd. The record was certified as complete and transmitted on September 28th. Farrell filed his initial brief on May 26th. All right, so the statement of facts. And here we go with the statement of facts, which is where we learn all about what actually happened and what he's complaining about as he files for his appeal. The statement of facts contained in Farrell's brief is the argumentative and is denied. The state relies on the following statement of the facts. On November 25th, 1996, Lake County Sheriff's Deputy Jeffrey Taylor was dispatched to 24135 Green Tree Lane in response to a call to 911 from a person who had returned home and found her parents apparently deceased. On arriving at the scene, Deputy Taylor was met by an individual who was, in his words, hysterical. Deputy Taylor searched the residence and found a male subject and a female subject, both of whom were obviously deceased. Deputy Taylor secured the scene and began gathering information. As a result of the information gathered and of the scene, a BOLO was issued for a blue Ford Explorer vehicle, which was missing from the residence, as well as for Heather Windroff, a juvenile who was supposed to be at the residence but was not. Okay, a child as well, huh? Barney Caudell is a crime scene technician with the Lake County Sheriff's Office. He became involved in this case about 11 p.m. on November 25th, 1996, when he was dispatched to the crime scene. Deputy Caudell went into the sheriff's office and, together with crime scene technicians, Gene Cushing, they located the major crime scene's vehicle and then went to the scene. The area outside of the residence was searched, and at about 4:09 a.m., the first entry into the residence took place. Caudell identified various photographs that were taken at the crime scene, including photographs of the victims and photographs of some of the scene itself, which showed the various dresser drawers had been emptied onto the bed and that the phone in the master bedroom had been disconnected. The following afternoon, the crime scene processing had begun, sufficiently completed to allow the removal of the victims' bodies. That's a long time to leave those bodies in that house like that. It's sad. At about 2:30 p.m. on November 26, 1996, the medical examiner was admitted into the residence where she conducted a visual examination of the bodies prior to their removal. And various shoe prints were found on the floor, which were photographed. On November the 28th, 1996, Deputy Caudell traveled to Baton Rouge, Louisiana, where he came into contact with Farrell. Now, here's the question I want to know. How did they know it was Farrell? Farrell was photographer. Sorry guys, let me repeat that. Farrell was photographed, and in addition, photos of the soles of his shoes were taken. While in Baton Rouge, Deputy Caudell also processed a blue Ford Explorer. Okay, so they stole the vehicle is how Farrell was caught, apparently. Okay, so he processes the blue Ford Explorer. The vehicle displayed a Kentucky license plate, but the license plate did not belong on the vehicle. A wooden stick wrapped with a black electrical tape was found on the passenger side rear floorboard of the vehicle. Based upon his observation at the crime scene, Deputy Caudell was able to determine that Miss Queen's location was when she was first confronted of her killer, as well as the location where she received the fatal blows. Okay. Audrey Presson lived in Eustis, Florida for 15 years and moved to New York in June of 1997. She was acquainted with Farrell while she lived in Eustis and considered him to be a good friend. Farrell later moved from Eustis and talked on the phone with Miss Presson about once a week. She saw Farrell again on the night before the murders that gave rise to this case. On that evening, Farrell came by Audrey's house and introduced herself to 3 of his traveling companions. Scott Anderson, who was with Farrell, told Audrey, "We're going to have some fun tomorrow night," and Farrell stated that they were in town on unfinished business. Farrell did not appear to be under influence of alcohol or drugs at the time. Dr. Laura Hare is an associate medical examiner in District 5, which includes, which includes Lake County, Florida. Dr. Hare was involved in the investigation of this case and was present at the murder scene where the victims' bodies were removed. An initial examination of the bodies at the scene revealed that Mr. Windroff had multiple wounds to his head, face, and chest, and that Mrs. Queen had multiple injuries to her head, face, arms, and hands. Dr. Hare performed an autopsy examination on both victims. There were 22 separate wounds on Mr. Windroff's head. That's a lot. The wounds inflicted on Mr. Windroff fractured the bones of his skull and penetrated into his brain. In addition, there were 9 to 10 wounds to Mr. Windroff's chest area. Dr. Hare testified that, in her opinion, as a pathologist, a crowbar could have caused the injuries found on Mr. Windroff. Mr. Windroff had 2 fractured ribs, and his injuries are consistent with him having been struck a number of times by very hard or very heavy objects. Mr. Windroff died as a result of a chop wound and blunt impact to the head with skull fractures and brain laceration. That is extremely hard to do. That's a lot of pressure with something heavy. Dr. Hare also identified the injuries found on Mrs. Queen's body at the time of the autopsy. She identified some 21 separate wounds to her head and face area. In addition, a number of wounds were found on her head and arms. The wounds on Ioma Queen's arms are consistent with defensive wounds. I'm glad she tried to fight. Sad. Such wounds are consistent with someone being conscious and trying to defend themselves against an attack. Mrs. Queen died of chop wounds of blunt impact to the head with the skull fractures and lacerations. 3 of the injuries actually penetrated into the brain, oh my God, and severed the brain from the stem from the rest of the brain. It would not be possible for someone with a severed brainstem to resist an attacker. Oh, it's very sad. Jim Brinkley is a crime scene investigator for the Lake County Sheriff's Office. He took a number of photographs of the interior of the Woodruff's home, as well as taking measurements of the interior of the residence to reproduce a floor plan of the structure. Moreover, Mr. Brinkley collected a tooth that was found on the body of Mr. Windroff. Mr. Brinkley also used a special device and collected a scraping from under the fingernails of Mrs. Queen. James Welburn is a uniformed patrol officer with the Baton Rouge City Police Department. On November 28, 1996, Officer Welburn observed a Ford Explorer matching the description of a vehicle wanted in Florida in connection with a double homicide. Officer Welburn called for a backup unit and secured the occupants of the Ford Explorer. Officer Welburn identified Farrell and the Explorer from photographs taken at the time of the arrest. Farrell appeared to be the individual who was in control, to whom the others looked for leadership. Farrell called Dr. Wade Myers to testify out of order about the results of his evaluation of the defendant. Farrell told Dr. Myers that he had used LSD 40 or more times and would laugh inappropriately. Dr. Myers diagnosed Farrell with schizophrenia. This is kind of a weird word. I don't think I'm saying this right, but I think it's schizotypal. So it's SCHIZOTYPAL. Okay, personality disorder, as well as dysthymia or depression, polysubstance abuse, and a learning disability in the area of mathematics. Dr. Myers is of the opinion both mental mitigators apply to Farrell. Dr. Myers administered various tests to Farrell, but the testing results of the million tests were invalid. Okay, let's see. I have not heard of that test. I don't really know what it is. Farrell's test scores indicate that he was not telling the truth. This undercuts Dr. Myers' conclusions that Farrell was abused by his grandfather, who was interviewed by Dr. Myers and denied such abuse. Dr. Myers had forgotten that Farrell had given the police in Louisiana a false name, but admitted that Farrell stated that he would fuck with them so they couldn't call the police, and that he would break their knees if they tried to be heroes. Okay. Farrell stated that he passed by one house because he didn't kill anybody under 16. Mrs. Queen's brain stem was severed from her spinal cord, and as a doctor, Dr. Myers knows that movement following that event would not be possible. Farrell does not have multiple personalities and is of average intelligence. Dr. Myers did not diagnose Farrell as having a conduct disorder. However, Farrell meets a number of the criteria for a diagnosis of conduct disorder, including among the incidents which met those diagnostic criteria are Farrell's expulsions from the high school. I'm sorry. Wait a minute. Those diagnostic criteria are Farrell's expulsion from high school for threatening to cut a teacher's throat. Oh wow! So he was just cruel his entire life, it seems like. Okay. Throwing a knife at his mother and kicking another individual in the face. Having self-reported being physically cruel to other people, as well as having self-reported beating cat. Okay, here we go. It always comes back to this. These people, it always started that they were abusive as children, that they killed and abused animals as children. Okay, even Letitia Stouch had a little criminal history from her childhood. She sure did. Remember, it was talked about. So, from cruelty to others, as well as having self-reported beating cats to death and having broken into an animal shelter and mutilated dogs. There you go. Despite the presence of a sufficient number of the diagnostic criteria to support a diagnosis of conduct disorder, Dr. Myers did not make the diagnosis of Farrell. Farrell's scores on the MMF1 testing indicated a strong possibility of malingering, just like Letitia Stouch. Malingering, yes. Okay. Farrell's behavior in hiding when a car approached, avoiding houses with children because he did not believe in killing people under 16, and avoiding houses with sophisticated security devices indicates that he does not want to be caught and is thinking about what he is doing. Farrell knows the right from wrong, and he often lies to get out of trouble. And that's typical, isn't it? So Farrell's involvement with the occult did not seem to be connected in any way to his aggressive behavior. Mr. Timothy Farrell is a forensic, this is terrible. Mr. Timothy Petrie is a forensic analyst with the Florida Department of Law Enforcement, Orlando's crime laboratory. He has previously testified and been qualified as an expert in the field of forensic serology and stain identification. Mr. Petrie identified various items of evidence. Human blood was found on the boot taken from Farrell and on the gloves found in the Ford Explorer. Farrell was permitted to call Dr. Mary Kropp out of order. Dr. Kropp testified concerning his opinions and conclusions about the defendant, and on cross-examination testified that Farrell tried to portray himself as more mentally ill than he was. Another Letitia Stouch right here. So common, isn't it? Dr. Kropp did not believe Farrell's story of multiple personalities. Oh, here we go again. Another one of Letitia Stouch's little... she tried the same thing, remember? Except Dr. Lewis fell for it, because if you ever go back and watch Dr. Lewis, every person that she ever talks to or anything that she's ever put out that's been documented, these people absolutely have DOD, all right? Or DID. It's called DID, all right? So, here we go. And, okay, see, on cross-examination, Then he goes, Dr. Kropp did not believe Farrell's story of multiple personalities and did not see any psychotic behavior during the testing or interview process. Claiming to be, here we go, this is it right here, guys, right here. Claiming to be a vampire is a way of getting attention. Farrell does not truly think that he is a vampire. Farrell knows right from wrong, and when he entered the garage of the Wendorf home on the night of the murders, he found a better weapon, thinking he might as well enjoy it. Farrell told Dr. Kropp that he swung the crowbar at Mr. Wendorf's head about 5 times and stopped just short of hitting him. On the 6th occasion, Farrell thought, who cares, and struck Mr. Wendorf approximately 25 times with a crowbar. Dr. Kropp does not believe that Farrell is insane. Farrell can distinguish right from wrong and conform to his conduct to the requirements of law if he chooses to do so. Farrell has a discipline problem in the law. Farrell has a discipline problem in the Lake County Jail. Ann Montgomery is the director of the operations at the Religious Technologies and is responsible for running the forensic department. The facility is a DNA testing laboratory which exclusively performs DNA typing. Mrs. Montgomery was accepted as an expert in the field of DNA analysis. Foreign DNA material was found under Mrs. Queen's fingernails, and it was not possible to exclude Farrell as the donor of that material. The material found under her fingernail is consistent with Farrell's DNA profile. Moreover, the blood found on Farrell's boot is consistent with Mrs. Queen's DNA profile. Mr. Wendorf could not be excluded as the donor of the blood found on Farrell's jeans. Mr. Wendorf cannot be excluded as the donor of the blood found in the bloody shoe prints found on the tile floor and the bloodstains found on the Ford Explorer. Deborah Fisher is a senior crime laboratory analyst assigned to the latent and print section of the Florida Department of Law Enforcement at the Orlando Regional Crime Laboratory. Shoe print identification is part of her function. Mrs. Fisher examined the latent shoe prints collected from the crime scene and compared them to the boots taken from Farrell. Mrs. Fisher was able to conclude that the left boot taken from Farrell probably made the impression collected from the crime scene. Mrs. Fisher was further able to determine that the footprint found on the tile taken from the floor of the Wendorf's residence was made by the right boot collected from the defendant. Desiree Nutt testified that she was employed at the Lake County Jail in December of 1997. Farrell was housed in the jail at that time, and she came into contact with him. On December 3, 1997, Farrell made statements to Mrs. Nutt regarding the security at the Lake County Jail and made various statements concerning his intent to attempt to escape from custody. Oh, another Letitia. I wonder if he measured the window and then lost weight to see if he could fit in that window to escape. I wonder if he did. Oh my God. Farrell came to her. So he was going to escape. Shannon Yobe lives in Eustis, Florida, and knows the defendant from school. Farrell came to her house in Eustis, Florida on November 24th, 1996, the Sunday before Thanksgiving. Farrell was accompanied by 3 other people who were introduced to Mrs. Yobe, and at that time, Farrell was driving a reddish maroon older car. On November 25th, 1996, Farrell and his traveling companions again appeared at Mrs. Yobe's house. She allowed Farrell to make a telephone call to Heather Wendorf. And during that telephone call, so how does he know Heather Wendorf, right? Because is that Mr. Wendorf's daughter, okay? So he makes a telephone call to Heather Wendorf. And during that telephone call, heard Farrell getting directions to Mrs. Wendorf's house. Before leaving Mrs. Yobe's residence, Farrell stated that he was going to steal the Wendorf's car because his car wasn't working properly, and that he was going to kill Heather Wendorf's parents. So she overhears this, and she doesn't call the law. She doesn't report it. And we have another Melanie over here, or another Zalim over here, and doesn't realize that she just overheard what the plan was and didn't report it. So Farrell states that he was going to steal the Wendorf's car because his car wasn't working properly, and that he was going to kill Heather Wendorf's parents because he wanted their car. At no time did Mrs. Yobe At no time was Yobi in contact with the Farrells did he appear to be intoxicated or under the influence of drugs or alcohol. Suzanne LeClaire lives in Eustis, Florida, and is Janine LeClaire's mother. Mrs. LeClaire knows Heather Wendorf and knew the entire Wendorf family. On November 24th, 1996, she received a telephone call at her home from Shannon. On November 25th, which is Janine LeClaire's birthday, Heather Wendorf called the LeClaire's residence. After dinner was finished, Mrs. LeClaire noticed that her daughter's door was open and that she was not home. Janine was waiting at the end of the driveway for Heather Wendorf, who was planning on running away from home. Okay, so these two girls were going to run away from home. Okay. Mrs. LeClaire attempted to call the Wendorf residence, but the phone was dead. Mrs. LeClaire then drove over to the Wendorf residence, which was not a great distance away, and observed law enforcement presence at the scene. Oh no. So I wonder if he picked those girls up and that's how they got involved. Well, let's just read on. Charles Frazier is the Seminole County, Florida sheriff. He's a deputy. During the week of Thanksgiving 1996, he found a small red vehicle abandoned on State Road 600, which is also known as 17-92, nearing the lakefront in Sanford. A Florida tag was displayed on the vehicle and was the communication center. Okay, wait a minute. A Florida tag was displayed on the vehicle, and when the communication center ran the tag, it came back registered to a Ford Explorer. Oh, they switched the plates. Isn't that nice? Subsequently, it was determined that the red car belonged to an individual from Kentucky. The Lake County Sheriff's Office was sent personnel to the scene, and the vehicle recovered by Deputy Frazier was towed back to the Lake County for processing. Ron Shirley is a Lake County Sheriff's Office crime scene technician. He processed the vehicle that was recovered from the Stanford, Florida area. He identified the license plate that was found in the vehicle. Lady Freedom, hang on. Anyway, so he identified the license plate that was found in the vehicle and also identified a map of the state of Florida that was found under the driver's seat. Deputy Al Guzzler testified that he investigated the credit card transactions for Mr. Wendorf's Discover card. The investigation revealed that 3 transactions on November 26th, Walmart in Tallahassee, an Amoco in Tallahassee, and a Shell station in Crestview, Florida. Those cities are located on Interstate 10 between Tavares, I'm probably not saying that right, between Tavares and Baton Rouge, Louisiana. Dennis Moran, a homicide detective with the Baton Rouge, Louisiana Police Department, on November the 28th, 1996, Detective Moran received a telephone call from the Lake County, Florida Sheriff's investigators regarding the Waldorf homicide. A telephone call from a suspect in the Wendorf murders had been made. Whoa! I thought nobody had made a call. Okay. A telephone call from a suspect in the Wendorf's murders had been made to a family member in South Dakota from a telephone located in Baton Rouge. The Baton Rouge authorities were advised that the suspect's vehicle was this 1993 Ford Explorer that was blue in color, bearing a Kentucky license plate. The vehicle was located at a motel, and its occupants were taken into custody and brought up to the police department. The 4 individuals who had been brought in were provided with bathroom facilities as well as being provided with food and drink. Ultimately, Farrell gave a statement to law enforcement that was videotaped. I'd love to see that videotape. I wonder if I can get it. Thomas Dewey is a detective with the Baton Rouge Police Department. On November the 28th, 1996, he was assigned to the Homicide Robbery Division of the Police Department. He became, oh my God, quit sending me text messages. Come on back. Go back. Uh-oh. I got to go back and get this again. Hang on a minute. Okay, turn it around. Okay. We just talk about Thomas Dewey. Okay. Ultimately, Farrell gave a statement to law enforcement that was videotaped. Thomas Dewey is a detective with the Baton Rouge Police Department. On November 28, 1996, he was assigned to the Homicide Robbery Division of the Police Department. He became involved in the Farrell matter and transported Farrell from the scene of his arrest to the detective division's offices. Farrell commented to Detective Dewey that he was glad to be caught because he had been on the run for several days. Sure, he was glad to be caught. Okay, let me plug in my computer. Hang on. I was using my phone. I was charging my phone with my computer thing because it was almost dead. Hang on, guys. Good. Now let's go back. Detective Dewey attempted to discourage Farrell from talking because he knew that he was a juvenile and did not know what the case was about. Wait a minute. He had been on the run for several days. Detective Dewey attempted to discourage Farrell from talking because he knew that he was a juvenile and did not know what the case was about. Detective Dewey was present during the interview with Farrell and stated that Farrell was very nonchalant about the whole incident and bragged about how he was the strongest one of the other people looked toward him because he was the leader of his group. Farrell came across as wanting to talk about the murders and bragging about them. Okay, so Sergeant Ben Odom is a sergeant with the Baton Rouge Police Department, robbery homicide. On November 28th, he came in contact with a defendant after Farrell was taken into custody. Ultimately, Farrell executed a written Miranda warning. Farrell executed a written Miranda warning waiver and gave a statement. Farrell was not under the influence of alcohol or any other controlled substance. Detective Guzzler testified again and authenticated various videotaped interviews of the defendant. In those videotapes, Farrell stated that Scott Anderson was following right behind him, like a little lost puppy. Was following right behind him like a little lost puppy and went on to admit beating both victims to death with a crowbar. Farrell stated specifically that Anderson was in the house but did not take part in the actual murder. A second videotaped statement between Farrell and Lake County Sheriff's Detective Guzzler was also played for the jury. Farrell stated that he had read his rights and understood them. Farrell stated that he looked for a better weapon in the Wendroff's garage because all he had was a stick. Farrell found a crowbar, which he thought was a better weapon. Farrell admitted to beating both victims to death and taking Mr. Wendroff's wallet, keys, and some other property from the house. Let me go back there. Paula Queen. Okay, so it says Paula Queen Loki is Faith Queen's eldest daughter. Mrs. Loki testified about the loss she had in her family and the community suffered as a result of Mrs. Queen's murder. Robert Wendroff is Richard Wendroff's youngest brother and testified about his loss as a result of his older brother's murder. Farrell presented various witnesses who testified concerning his background and early life. Ashley Elkins testified that Farrell always tried to intimidate people and wanted her to be afraid of him. Mrs. Elkins testified that Farrell was manipulative and would often try to play on the emotions of others to get what he wanted. Farrell stalked Mrs. He's a stalker too, just like Letitia. Great. Farrell stalked Mrs. Elkins for a period of time and told her that he was powerful and thought it was funny that he could hurt people. Stephen Murphy testified that he is the one who crossed over Farrell. Stephen Murray testified that he is the one who crossed over Farrell into the vampire lifestyle. Murphy testified that one of the laws of being a vampire is that killing is forbidden and that the vampire is not allowed to take blood of anyone without obtaining their permission. Oh my God, this is kind of funny. He taught and stressed these. He says he taught and stressed these precepts to Farrell when he crossed him over. Matthew Goodman also testified that Farrell would regularly manipulate people and try to control others. Captain Kevin Drennan is the supervisor of Lake County Jail. He testified that Farrell was found with a shank. He told y'all he was going to try to escape. The shank in his possession. During cross-examination, Sandra Gibson, Farrell's mother, testified that the hospital records indicating that there was nothing wrong with Farrell at the time of his birth are incorrect. Oh, okay, Mom, please don't do this to yourself. Farrell was supposed to appear in court on November 25th on the day the murders of issue. Okay, so he had been in trouble before. Here we go. Farrell was supposed to appear in court on November 25th, 1996, the day of the murders at issue in this case took place. Mrs. Elizabeth McMahon, this is kind of light, okay, is a clinical psychologist who has evaluated the defendant. She is of the opinion that Farrell meets the criteria for a schizophilic personalities disorder. She has no biases to believe that Farrell could not appreciate the criminality of his conduct or conform his conduct to the requirements of the law. She does, however, say that his ability to stop behavior is somehow impaired. Further, Dr. McMahon believes that Farrell can function appropriately in prison. Dr. McMahon is opposed to the death penalty. She found no indication of brain damage, no indication that Farrell suffered an abnormal birth, and moreover testified that he has an average IQ. Farrell was running from the law when he left Kentucky, and he was simply not going on vacation. Farrell's behavior during and following the murders indicates an attempt to avoid being caught. In rebuttal, the state presented the testimony of the following witnesses. Dennis Fisher is a principal at the elementary school in Graves, Kentucky. In 1996, he was an assistant principal at Callaway High School, which is the city of Murray, Kentucky. In the capacity, Mr. Fisher was in charge of discipline at the school, and he had multiple interactions with the defendant. While Farrell dressed in a somewhat unusual fashion that was not particularly a problem, Farrell's behavior in not doing what was expected of him was the problem that the school had with him. And Mr. Fisher counseled and met with him on numerous occasions. Mr. Fisher tried to nurture Farrell's good qualities, but Farrell's responses were, at best, nonchalant. In conversation with Farrell's mother, she had told Mr. Fisher that she was afraid of Farrell and that he had gotten just physical with her. Mr. Fisher testified that he and the school system gave Farrell all the breaks in the world, but that Mr. Farrell would not conform to the system. And in an incident involving a teacher at the Callaway County High School, Farrell stated that he could slit the teacher's throat. Deborah Mooney is a social worker in Callaway County, Kentucky. Oh gosh, I'm so tired of those things popping up here. In 1996, she was employed as a social worker at the Western Kentucky Regional Mental Health Center. In her work as a mental health professional, she came in contact with Rod Farrell on May the 2nd of 1996. She wanted Farrell to continue treatment with her, and there were a number of other mental health professionals available to him at the Western Kentucky Regional. Farrell missed the next 3 scheduled appointments and did not return until October the 3rd. She was unable to meet with Farrell on the 3rd because she had another client who was expressing suicidal thoughts, and moreover, because she did not expect Farrell to keep his appointments. She brought in the potentially suicidal client instead. Farrell never kept any other appointment with her. She was not able to help Mr. Farrell, despite her best efforts, because he was non-compliant and missed several sessions. Farrell exhibited normal thoughts, normal mood and affect, and normal insights, above normal intellect, and was alert and oriented. Okay. Jane Ann Turner is a court-designated worker in Callaway County Juvenile Services. Okay, this I would show y'all this. It's just okay. Let's see if I can turn it around. See how light this is? I mean, it's kind of hard to read. I don't know if you can see that. See how light it is? It's kind of hard to read. It's causing me to make a lot of errors, but it's okay. We'll get through it. Of course we will. So Jane Ann Turner is a court-designated worker in Callaway County for Juvenile Services. Farrell's mother filed a complaint with social services based upon suspected drug use by Farrell, as well as her concerns about his involvement in the occult. Moreover, Farrell was staying out and not obeying his curfew and was bringing over friends that his mother did not approve of. As a result of the complaint filed by Farrell's mother, there was an agreement entered into where Farrell was required to perform certain things as part of the disposition of the status complaint. Farrell initially kept the terms of the agreement, but began breaking his curfew and being verbally abusive to his mother shortly thereafter. Ultimately, the agreement was terminated and the complaint was turned over to the court as a juvenile petition. The matter was referred to the court, and Farrell was expected to return to court on November 25th. Here's the summary of the argument. Farrell claims of all impermissible restrictions on the length of time allowed for closing argument was not properly preserved by timely objections. Moreover, the trial court did not abuse its discretion in limiting closing argument to 45 minutes to the sides. Okay, so like they were supposed to only give 45 minutes, but they did to one, but not the other. That's what his complaint is. In any event, under the facts, assuming the arguendo that some error took place, it was harmless. The claim of judicial bias is procedurally barred because the motion of disqualification was made within 10 days of the discovery of the facts supporting the motion. Alternatively, this claim is meritless because the facts do not support it. Farrell's claim that the trial court restricted voir dire improperly is not supported by the records. There is no legal bias for his claim, and in every event, assuming that some error occurred, it was harmless. The lay witness opinion testimony claim has no legal bias. The complaint of testimony was opinion testimony in the first place. Moreover, that testimony was given during the penalty phase of Farrell's trial with the attendant relaxed of evidentiary standards. Finally, any error was harmless beyond a reasonable doubt under these facts. The claim concerning the denial of the motion to suppress has no legal bias. A second unchallenged statement that included a full confession to the murders was admitted into evidence. Any error associated with another statement was harmless because the evidence was placed before the jury through a statement that Farrell concedes was properly admitted. Moreover, both statements were properly submitted, and for that reason, there is no bias for a relief. Okay. The trial court properly denied Farrell's motion for a change of venue. A fair and impartial jury was selected, and there is no error. In any event, Farrell has not identified any juror who he claims was biased, nor has he alleged that his trial was not fair and impartial. Farrell's claim concerning the admission of testimony about his plans to escape from the Lake County Jail is not biased for reversal. The complainant's testimony was properly admitted. In any event, the testimony was used by the sentencing court to support a mitigating circumstances found in the sentence order. Moreover, any error was harmless beyond a reasonable doubt. The sentencing court properly found that the cold, calculated, and premeditated aggravator based upon proof beyond a reasonable doubt of the elements of his aggravating circumstances. A lot of words there. Settled law supports the finding of this aggravator. The sentencing court properly found that heinous, atrocious, or cruel aggravators, the components of this aggravating circumstance, was established beyond a reasonable doubt, and the heinous, atrocious, or cruel aggravator was properly found under settled Florida law. Death is a proportionate sentence in this case. Four strong aggravation exists: cold, calculated, and premeditated, heinous, atrocious, or cruel, prior violent felony, and during the course of a felony. Those aggravating circumstances outweigh the mitigation, and death is the appropriate sentence. Farrell claims that it would be unconstitutional to execute him because he was 16 years old at the time of the murders is not a bias for relief. The United States Supreme Court, its precedents establishes that a sentence of death can constitutionally be imposed on a 16-year-old killer, and that the court should honor that precedent and uphold the sentence of death in this case. In the final sentencing order, the trial court erroneously found that the avoiding arrest aggravator was not proven by the state. The evidence established that the dominant motive for the murders was the elimination of witnesses, which is the standard for finding this aggravator, and the victim is not a law enforcement officer. The trial court also erroneously excluded testimony that Farrell was fleeing law enforcement. Such testimony was relevant to the avoiding arrest aggravator and should have been admitted. Here's the arguments. Now, here we go. How long have we been on? Oh, almost an hour. Okay. We might not get to back to Aubrey Trail today, but we will get back to him because remember, he claimed he was a 500-year-old vampire as well. I mean, I wish I could get the, I'm pretty sure we will not be able to get any of the video from this case because he was 16 at the time he was arrested. Even though he was tried as an adult, he was still 16 at the time he was arrested. Because they had to go before the court to decide that they were going to try him as an adult instead of in the juvenile. Agreement, the limitation of closing argument claim. Here we go. On pages 23 through 33 of the initial brief, Farrell argues that the trial court abused its discretion by limiting closing arguments to 45 minutes to the sides. Whether his claim is properly preserved is, at the very least, an open question. However, it is clear that the trial court did not abuse its discretion in imposing a limitation on the length of the closing arguments. The claim has its foundation in the following cryptic comment by the trial court. I intend to give both of you over noted objection 45 minutes each for closing, state first, defense last. Those time parameters were emphasized by the trial court on at least 2 subsequent occasions. The record does not reveal and no testimony established which party's objection was the noted objection referred to by the trial court. Farrell's argument is, from its inception, based upon the assumption that it was the defense that objected, that the assumption finds no support in the record. At no time did the defense counsel voice an objection or attempt to convince the trial court to reconsider any prior ruling. Defense counsel's closing argument consists of some 25 pages of transcript and appears to have lasted approximately 45 minutes. Defense counsel did not assert at the conclusions of the argument that there was additional matters to be argued and did not identify any argument that was not made as a result of the time limitation and did not ask the trial court to reconsider its decisions. The limit closing argument to 45 minutes because it's so, nothing is preserved for the appellate review. The issue contained in the claim is analogous to a claim for relief based upon the denial of additional preemptory challenges, which requires that all challenges be exhausted and additional challenges be requested for the use against specified linear members before any claim is preserved for the appellate review. The claim contained in Farrell's brief is the functional equivalent of each of the preemptory challenges claims, and because Farrell never even argued to the court that he would make an additional argument if given the time, he has preserved nothing for his court's review. Of course, this claim is reviewed under the abuse of discretion standards. Before the trial court and can be placed in error, the court should have the benefit of objection by defense counsel, which placed the court on notice of the substance of the objection. Oh my gosh. Lots of words here, lots of words. Nothing resembling such an objection appears in the record, and for that reason, nothing is preserved for the review of the court. In addition, not being preserved for appellate review, the records as reconstructed is considerably less clear on this issue than Farrell suggests. According to the testimony at the record reconstruction hearing, only Farrell remembered his attorney objecting to a 45-minute limitations on closing argument. Farrell was very specific that this objection was made in open court, not during a bench conference, before the jury was brought into the courtroom. Farrell's trial counsel thinks that she probably objected. Okay, this is bad because his own attorney is saying, well, I think I objected. Okay. I think she probably objected to the limitations on closing arguments, but could not specify or recall. The courtroom deputy who served as bailiff during Farrell's trial had no recollection of any objection by defense counsel. The courtroom clerks had no recollection of the objections by the length of time allowed for the closing arguments and testified that such an objection would be reflected in her chronological summary in the court file if such objection was made. The court reporter who took Farrell's trial had no recollection of any objection by the defense counsel. Finally, neither of the prosecutions involved in this case had any recollection of any objection to the length of the closing argument. The trial court stated I will state for the record, I also have no specific recollection as to whether or not defense counsel made some verbal objection at some point when we were not on the record. But I will reiterate, it has to be that defense counsel indicated to me at some time that she objected to the 45-minute limitations, because I would not have said over objections otherwise. Okay, that's a little weird. Ooh, it's so warm here. Okay, despite that statement of what has to be when all the evidence is considered, it points toward the absence of an objection. Of the individuals involved, Farrell is the only person who has any recollection of an objection to the limitation of closing statements. Obviously, Farrell has a greater interest in the outcome of this litigation than anyone else, and further, is the one person with a track record of dishonesty and deceit. If, as Farrell claims, such objections took place in open court in the presence of the prosecution, the bailiffs, the court reporter, and the clerk, someone would have remembered the objection being made, and moreover, it would be recorded in the clerk's record as in the transcript of the proceedings. However, the state of the record is that only a person who has any recall about the matter in question is the one person with the greatest vested interest in the outcome of this case. Farrell's testimony is completely incredible, and is unworthy of belief. When the remaining testimony is fairly considered, the testimony leads to the conclusion that no objection was made by the defense counsel for the length of time allowed for final summation. The conclusion is bolstered by the testimony of the two persons whose duty it would have been to record such objections, the county clerk and the court reporter. Neither of those individuals had any recollection of any objection being made. In fact, as the court clerk testified, such an objection would be indicated in her court file, and if it had been made. The absence of such notations, coupled with the total absence of any such objections in the transcript itself, is evidence that no such objection was made. There is no persuasive evidence to the contrast, and there is no basis for relief on this claim because it was not properly preserved for the appellate review. In addition to the foregoing reasons for the denial on this claim, even assuming that an objection was made and that it was timely and sufficient to preserve any issues for review, there is no basis for relief because there was no abuse of discretion on the part of the trial court. As this court has repeatedly held, we clearly held the trial courts as have broad discretion in the procedural conduct of the trials. And it goes into Moore versus State. It talks about a bunch of different cases. Okay. He goes. I have to go. I'm not going to read all the different cases that they bring forward about when this has happened before. Okay. So the limitation of the length of closing argument. There is no rule that requires the closing argument to be any particular length, and there is no formula for calculating reasonable time. However, under the facts of this case, 45 minutes was enough time for the defense counsel to present an argument that clearly and concisely stated the defendant's position and argument in the support of the sentence. The sentence is less the death. Okay. Finally, the facts of this brutal double murder obviously made it incredibly difficult to argue against a sentence of death, and made it difficult at best to adduce mitigation sufficient to persuade a jury to recommend a sentence less than death. Under these facts, it is not possible to conclude that Farrell's jury would have recommended a different sentence if defense counsel had been allowed an unlimited amount of time for closing argument. Farrell cannot demonstrate any prejudice, cannot demonstrate as an abuse of discretion, and moreover cannot demonstrate harmful errors. It was an error to limit the length of closing argument, assuming it was limited, and the state does not concede that it was. The error was harmless beyond a reasonable doubt. And then it goes into the different cases that they want to state about it. Okay. And then it goes number 2, the judicial bias claim. Oh boy, how many pages this is? I don't really know. Okay, 78 pages, and we are over here on page 34. All right, but it's interesting stuff, really. Okay, the judicial bias claim. On pages 34 through 40 of his brief, Farrell claims that he is entitled to relief because of the trial court's appearance of partiality. Initially brief at 40. Initially in page 40 of the brief is what he's talking about. In an effect to create a bias for relief from whole cloth, Farrell attempts to force this case into the facts of various 4th District Court of Appellate's case, which held, in essence, that the trial judge went too far in assisting the prosecution. Those cases are distinguishable on their face and do not support Farrell's position and are not biased for relief. Moreover, Farrell is not entitled to relief on this claim because it is a procedural that's barred. Florida law is settled that a motion to disqualify a trial judge must be raised within 10 days of the discovery of the facts supporting the motion. There is no question that the facts now alleged as a bias for this claim of judicial biases were well known to Farrell at the time of the jury selection and could have been used as the basis for a motion for disqualification at that time. There is also no question that Farrell waited until long after his trial was over to raise these claims. Because Farrell did not comply with the Florida Rule of Judicial Administration Rule, and it names the rule, he has waived his right to seek relief on this case. Rule number 2 exists to ensure that claims of judicial bias are raised in a timely fashion rather than being held in reserve against adverse results and then being presented for the first time in an appeal. This claim is not available to Farrell and all relief should be denied. In addition, not having been properly preserved for review, this claim is meritless. In an effort to create an issue of appeal, Farrell argues that the trial court first appeared less than neutral during the jury selection. The initial brief on page 36, the true facts were the juror at issue, Jefferson, was late in returning to the courtroom during voir dire, which, as this court is aware, creates an unnecessary disruption in the proceedings by requiring that everyone wait until such time as the late prospective juror arrives. Such lateness has been held to supply a valid race-neutral reason for exercising a peremptory challenge appellate to the late juror. And then it talks about Turner versus State and all the different cases where this has happened before. And it makes no sense to suggest that the trial court's comments indicate anything other than practical problems that arise when one juror fails to follow the court's instructions. Whatever that does indicate, it does not indicate bias against the defense. Another component of this claim is Farrell's assertion that the trial court supplied the state with race-neutral reasons to preeminently challenge Juror Jefferson. That argument is, at best, based upon a strained reading of the record. The true facts are that during the discussion about the juror's absence, the state pointed out that Jefferson had said that he was opposed to the death penalty, but able to follow the court's instructions, which, as the state noted, was a proper bias for a peremptory challenge. Okay. Obviously, the state was well aware of the potential need to justify its peremptory challenges and did not need the court to provide the reasons for such challenges. The voir dire examination of Jefferson provided reasons for challenging him, and the fact that the courts and the state noted the same reason is hardly surprising unless Farrell believes that the fact that the court noted certain reasons for exercising a peremptory challenge somehow precludes the state from using those same reasons. Such a conclusion is nonsense. The trial court did nothing improper, and there is no biases for a reversal. Farrell's sentence should be affirmed in all respects. Okay. Restrictions on the voir dire claim. See, he's got a bunch of silly procedural reasons as to why he wants a new trial, which none of them worked, but anyway. And I believe the reason why he was taken off the death row and put on life in prison instead is because he was 16 when this happened, even though he blamed it. You know. On pages 41 through 45 of his brief, Farrell argues that he is entitled to relief based upon limitations on voir dire examination. Farrell does not claim that the jury that tried the penalty phase and recommended death unanimously was in some way biased. Instead, he claims it appears to be entitled to a new penalty phase because the trial court sustained the state's objection to questions concerning smoking and school detention because that violated an unidentified constitutional right and resulted in some unknown prejudice. The true facts are that Farrell was allowed to engage in extensive voir dire questioning of the jurors who had already completed the questionnaires, to the extent that the court remarked that the defense voir dire lasted, at that point, some 2.5 hours compared to the 1 hour for the state. Moreover, the transcript of this case shows that the voir dire consumes 5 volumes of transcripts, which is hardly a limited amount. The first identified complaint is that the trial court sustained the state's objections for certain questioning from the state's reason that it calls for them to commit to a positive position. Okay, hang on a minute. It's tiny and it's dark. I can't hardly see. It's kind of light. It calls for them to commit to a position that they don't know any facts and haven't been given the law. Okay, I get it. In a position on the record that is omitting from Farrell's brief, the prosecution pointed out that the question is, will they follow the law? To which the court responded, that's correct. To the extent that the further discussion is necessary, it is clear that the proper inquiry in whether the prospective jurors will follow the law, not whether the jurors will. In the abstract, always vote for the death penalty. Okay, and that's another thing that's perceived. People, even in Chad Daybell's case, there was some notion that, they were going to give him the death penalty no matter what because they had to. Okay, so it was just some perceived notion that, well, if he's guilty, then he's got to get the death penalty. But that's not true. They don't have to. Okay. In abstract, always vote. Okay, so we talked about that one. Okay. Farrell next complains that the trial court improperly precluded further inquiry into the prospective jurors' feelings about the death penalty. The issue is based on cumulative questions that come late in the jury selection process after extensive questioning on the subject had been conducted. The facts are that the complaint of the matter occurred shortly before the final selection of the jury was completed and dealt with a juror who was removed permanently by Farrell. Farrell has not alleged that he was prejudicial in any way, nor has he alleged that any juror was not fair or impartial. In short, Farrell seeks reversal of his sentence of death when there is no error, when his rights were not affected in any way, and when he was tried by a jury that was acceptable to him. There is no basis for relief because under the law, the most favorable view of the matter possible in any error was harmless beyond a reasonable doubt. And then it starts giving the different other cases that this has been brought up in. To the extent that Farrell argues that Florida rule of jury selection begins at page 1644 of the record. Criminal Procedures .32181 was not complied with. His brief contains no more than a bare claim of noncompliance with the rule of the part of the trial court. However, there is no objection appearing on record in which Farrell alleges that Rule 3.281 was not complied with, nor is there any suggestions by the trial counsel that the voir dire was hampered in some fashion. There is no support for Farrell's claim of error, and there is no basis for the relief, assuming the argumento that a violation of Rule 3.281 would in fact compel such a result. Finally, and assuming for the purposes of argument that there was some error, the error was harmless based upon Farrell's initial brief. The most that has been alleged is that claims that a rule of criminal procedure was not followed. There is no citation to the record to support that claim, nor is there any explanation as to the sort of prejudice resulting from the alleged error. The most that has been alleged is a technical error that had no adverse effect on Farrell and is harmless beyond a reasonable doubt. And it gives another case where this has happened. There is no bias for relief. The opinion of the testimony claim. Here we go. On pages 46 through 50 of his brief, Farrell argues that the trial court erred in allowing what is described by Farrell as opinion testimony on the part of the state witness. The claim fails for the following reasons. The testimony of issue in its entirety reads as follows. Question. In your conversations that you had with Mr. Farrell, did the particular did he particularly tell you what he was doing in the state of Florida? Answer. He said that he was there. He was here in Eustis on an unfinished business. Question. Oh my gosh, what's these things we put popping up? Question. You had been a friend to Mr. Farrell and had spoken to him on a number of occasions. Is that true? Answer. Yes. Question. What did that mean to you, having known him and knowing how he spoke? The defense counsel. Your Honor, he starts to object to this. Your Honor, I would object to that this is speculative. She can't understand what was going on in my client's mind, nor what was meant by the statement, and we would ask that the witnesses not be allowed to answer. Then the court steps up. She wasn't asked that. She was asked what it meant to her. She can answer that. Overruled. Mrs. Presson. Question. And here's her answer. My understanding that it was unfinished business means that somebody has done somebody else wrong and they will pay for it. That's unfinished business. A fair reading of the records without interpretation to suit one's purpose demonstrates that the witness was not asked to speculate or otherwise interpret Farrell's statement. What the witness was asked to do, which was completely proper, was to testify as to what the phrase unfinished business meant to her. This is not improper nor speculative because the witness was not asked to interpret what Farrell said. In any event, the complaint of testimony came during the penalty phase of Farrell's trial, which the defendant relaxed evidentiary standards. Even assuming argumento that the testimony as issued should not have been allowed, Farrell cannot make the leap from technical errors to a bias for reversal. Under the facts of this case, any error was harmless beyond a reasonable doubt because Farrell was not prejudiced by the testimony at issue. And then it gives another case where this has been used before. Okay, so, and it goes, Farrell's death sentence should be affirmed in all aspects or respects. Number 5, the denial of the motion to suppress the claim. On pages 51 through 60 of his initial brief, Farrell argues that the trial court erroneously denied his motion to suppress the statement given to Louisiana law enforcement officers. The claim is not a basis for relief for the following reasons. The first reason that Farrell's claim of error in denying the motion to suppress the statement given to the Louisiana authority falls in because of second unchallenged statement given to the Florida law enforcement officers was also admitted during Farrell's penalty phase. Farrell does not challenge that the statement in his brief and in fact makes no reference to it at all. The unchallengeable statement is a full confession to the brutal murders, and because it is admissions was not challenged on appeal, even assuming that it was an error to admit it, the first statement in any error was harmless because the same evidence was placed before the penalty phase jury in the statement that Farrell concedes was properly admitted. Farrell's claim is internally inconsistent and, moreover, has no basis in law or fact. This court should deny all relief. In addition to denying relief on this claim, because it's based upon a flawed legal premise, the court should also deny relief because the state establishes that both statements were admissible into evidence at the hearing on the motion to suppress. The state established the defendants were not mistreated or abused in any fashion, that their basic human needs were attended to, and that Farrell was interviewed on 2 occasions for no more than 2.5 hours. Then it gives some other information. Little records stuff. The record further demonstrates that Farrell was given his Miranda rights on 3 occasions, and on each occasion stated that he understood his rights and was willing to talk to law enforcement. Despite understanding his rights, Farrell was offered no promises or inducements. It was not under the influence of alcohol or drugs, and moreover declined the opportunity to contact his parents. Farrell stated specifically that he was given the statement because it was the truth, not because he wanted to be able to see, Charity Keesey, or despite Farrell's hyperbolic efforts to create a coercive element surrounding his confession, the totality of the evidence establishes that his 2 confessions were given following and knowing voluntarily an intelligent waiver of his Miranda rights, which was not in any way obtained by improper coercion. The facts of this case are, if anything, less compelling than the facts of Bruno, which is another case. where this court held there was no police overreaching, and the fact of Bruno's confession was motivated in part by concern over the welfare of his son does not provide a basis for suppressing the confession. And it talks about Bruno versus state. The state carried its burden of providing the voluntariness of the two statements, and the trial court's denial of the motion to suppress is not clearly erroneous. And it gives another, bunch of other cases. The sentences of death should be affirmed in all respects. On pages 57 through 61 of his brief, Farrell raises a subclaim in which he argues that his confession is inadmissible in a Florida proceeding because it's inadmissible under Louisiana law. This claim collapses for several reasons. The first effect that Farrell's claim is that the admissibility of the confession under Louisiana law does not affect the admissibility of the confession in Florida penalty phase proceedings, where the only exclusion of evidence obtained in violation of the United States of Florida Constitution, and it gives the constitutional numbers, has not even alleged a violation of the United States Constitution, and because that is so, has not alleged any biases for reversal. This claim is also not a biases for relief because the second statement taken by Florida officers is not challenged herein. The statement, okay, so what happens is he gives a confession in Louisiana, and then he gives a second confession in Florida. But because they brought in the Louisiana confession, he's trying to have this thrown out because it should not, he's saying that it shouldn't have been put there. It shouldn't have been used because it was improper by the state of Louisiana's rules, but not by the state of Florida's rules. Okay. The statement was introduced into evidence and is not challenged on appeal. Because Farrell has conceded that the admissibility of that statement, the most that the issue does is raise an error that was harmless beyond the reasonable doubt. In light of the unchallenged, virtually identical evidence before the jury, this claim is not an issue, and the sentence of death should not be disturbed. Okay. The claim. Okay. Then he wanted to change the venue. Boy, he's just trying to pull out everything, hasn't he? On pages 62 through 66 of his brief, Farrell argues that it was an error for the trial court to deny his motion for change of venue, despite Farrell's protections. A fair and impartial jury was selected, and therefore there is no bias for relief. The facts of this case, at least with regard to the change of venue issue, are disturbingly similar to those of another Lake County double homicide in Henyard versus State. The court decided the identical claim in the following way. Okay, so it's discussing these things. Knowledge of the incident because of its notoriety is not in itself grounds for a change of venue. The test for determining a change of venue is whether the general state of mind of the inhabitants of a community is so infected by knowledge of the incident and accompanying prejudice, bias, and preconceived opinions that jurors could not possibly put these matters out of their minds and try the case solely upon the evidence presented in the courtroom. An application for a change of venue is addressed to the sound discretion of the trial court, but the defendant has the burden of showing that the setting of the trial is inherently prejudicial because of the general atmosphere and the state of mind of the inhabitants of the community. A trial judge is bound to grant a motion for a change of venue when the evidence presented reflects that the community is so perversely exposed to the circumstances of the incident that prejudice, bias, and preconceived opinions are the natural results. The trial court may make that determination upon the basis of evidence presented prior to the commencement of the jury selection process, or may withholding making the determination until the attempt is made to obtain an impartial jury in the case. Okay, and talk say. Ordinarily, absent an extreme or an unusual situation, the need to change of venue should not be determined until the attempt is made to select a jury. During the actual voir dire, each prospective juror was questioned thoroughly and individually about his or her exposure to the pretrial public publicity surrounding the case. While the jurors had all read or heard something about the case, each stated that he or she had not formed an opinion and would consider only the evidence presented during the trial. In making a decision further, the record demonstrates that the members of the Henyard's Vineyard, the Henyards Vineyard. Oh, this is weird. The members of the Henyards Vineyard did not possess such prejudice or extensive knowledge of the case as to require change of venue. Therefore, we find that on the record before us, the trial court did not abuse its discretion in denying Henyard's motion for change of venue. In this case, as in Henyard, the question is not whether the case was subject to publicity. Instead, the question is whether the jury that was impaneled to try the case was able to decide the case based upon the law and the evidence, putting aside any other knowledge about the case. A fair and impartial jury is what Farrell was entitled to, and it's what he received. There is no basis for reversal. To the extent that the further discussion of this claim is necessary, Farrell had not identified any juror who was seated to the trial of this case that was biased against him, nor has he even claimed that the jury was not fair and impartial. While Farrell may doubt that he could have received a fair trial in this case, as salacious as this was, as salacious as this one, this is not the standard by which change of venue motion is evaluated. Under Henyard, the denial of the motion for change of venue was proper. The sentences should not be disturbed. To the extent that Farrell complains that he did not receive a list of the prosecution's jurors in compliance with Florida Rule of Criminal Procedures. God, these things just keep popping up here. The record reflects that the required list was provided to counsel on the morning of the first day of the multi-day voir dire process. Farrell has not suggested he was not prejudiced in any way. And if there was an error, it was harmless beyond reasonable doubt. Okay? What page am I on? Oh, I'm on page 50. Oh, Lord, I don't know if I can finish this today. It's already been an hour and 26 minutes. I might have to come back to this. Okay. I think we'll read this next section. The inflammatory evidence claim. On pages 67 through 68 of his brief, Farrell argues that the trial court erred in admitting evidence of Farrell's plans to escape from the Lake County Jail. According to Farrell, this evidence was irrelevant to the penalty phase for the following reasons. This claim is not a basis for reversal of Farrell's sentences. Farrell's argument is based on the premises that the state somehow breached an agreement not to go into what Farrell labels as collateral crime. The argument is based on an inaccurate reading of the record. The true facts are that the complaint of testimony came through the reading of a written report prepared by the witness, which was admitted under past recollections records. Hearsay exception. Before the witness testified, the trial court stated, it can all be read, every word of it, as long as it qualifies as past recollection record, but not admitted. If the defendant won't agree to admit it, then we'll just have to do it the hard way. Oh boy. If the defense won't agree to admit it, we'll have to do it the hard way. Well, that's quite a statement, isn't it? When the record is read without slanting it to support a particular interpretation, it is clear that the defense counsel was well aware that the report detailing Farrell's escape plans would be read in its entirety to the penalty phase of the jury. In his brief, Farrell claims that the introduction of his statement to the Lake County Jail corrections officers were collateral crime evidence. This novel theory collapses because Farrell has not identified what a crime was introduced by the report at issue. While it is true that the evidence of Farrell's escape plan was introduced as a result, it is also true that the very evidence was cited to establish a mitigating circumstance in the court's sentencing order. It hardly makes sense that Farrell to argue against the admission of evidence that was relied upon to establish a mitigating circumstance. In addition, not to being evidence of a crime to begin with, the evidence at issue was turned on the state as used in mitigation. There is no bias or reversal because this claim has no legal bias. To the extent that this claim deserves further discussion, Florida law is settled that the determination of the admissibility of evidence at the penalty phase of a capital trial is based on relevancy. In the context of this case, the evidence of escape plans is certainly relevant to Farrell's ability to adapt to incarceration, and moreover is highly relevant to his character, which is the primary focus of the penalty phase proceedings. The complained of evidence was obvious relevance and was properly admitted. There is no bias for reversal, and Farrell should not be heard and Farrell should not be heard to complain, especially when the evidence upon which he seeks reversal was used to establish a mitigation, not considered one of the trial courts found another. Okay, wait a minute. Let me sit up. Let's see what, okay. So it says, it was used to establish one mitigator and not considered when the trial court found another. Farrell's complaint is unreasonable because he benefited from the admission of the evidence he's now challenging. Oh my, that's kind of funny. There was no prejudice, and hence, there is no basis for relief. Alternatively, even if the evidence at issue should not have been admitted, and even if it truly is evidence of a collateral crime, any error is harmless beyond the reasonable doubt. Under the facts of this double murder, and in view of the extensive aggravations, it is inconceivable that the jury would have recommended a life sentence had they not heard of Farrell's escape plan. Because that is so, there is no basis for reversal, because Farrell was not prejudiced, and any error was harmless beyond a reasonable doubt. And it talks about another, the Giglio super. Okay. The cold, and this is pretty good right here. The cold, calculated, and premeditated aggravators, which are very important in this case. On pages 69 through 73 of his brief, Farrell argues that his sentencing court should not have found the cold, calculated, and premeditating aggravating circumstances. This claim lacks merit. In finding that the cold, calculated, and premeditated aggravator apply to the murders in this case, the trial court stated, well, I think it absolutely does apply. It certainly does. He told somebody he was going to do this. He told somebody he was going to do this. And nobody ever called the law and said, hey, you better go check this out. Even though they heard about it, they absolutely heard about it. They testified they knew about it. The circumstance proves beyond a reasonable doubt by Farrell's statements on the afternoon of the murders that he was going to kill the victim. His careful surveillance of the home before the entry, the procurement of a deadly weapon in advance of his entry into the home, the lack of resistance of Richard Wendroff and the number, location, and severity of the wounds inflicted on both of the victims. And it starts about Stein versus State. These factors is given great weight. It should have been. It absolutely should have been. In setting out the facts of the case as established by the evidence the court has previously stated, Farrell and the group returned to Shannon Yohe's home to call Janine LeClaire and Heather Wendorf to tell them of the change of plans. Shannon Yohe was told of the group's car problems and heard a discussion among Farrell and his group that they would take the Wendorf's vehicle. Farrell discussed with the group, in Shannon Yohe's presence, they planned to kill Heather Wendorf's parents and take their Ford Explorer vehicle. Farrell spoke to Heather Wendorf by telephone, drew a map to her house from her directions, and shortly thereafter left the Yohe residence. The group arrived in the area of the Wendorf residence and met Heather Wendorf down the road from the home. So apparently what this is telling us is that the daughter knew all about this and she was home. Okay, she had left the house and got picked up down the road. Is that what you're telling me? The group arrived in the area, so he met Heather down the road from her home. Farrell sent the three girls, Heather, Dana, and Charity, to visit Heather's boyfriend and pick up Janine LeClaire. Farrell and Anderson remained in the area of the Wendorf home in order to burglarize the home and take money on the vehicle, and to kill Richard Wendorf and Noah McQueen. In furtherance of this plan, both had armed themselves with clubs. Okay, so the girls were not there, but they absolutely knew about it. They should be co-conspirators, absolutely. Farrell and Anderson engaged in exterior search of the Wendorf home to determine where entry could be made. They then entered the home through an unlocked garage entry door and searched the garage to find a better weapon. Several potential weapons were considered before Farrell determined to arm himself with a crowbar. Entry was then made into the home, and one phone was pulled from the wall. Richard Wendorf, who was asleep on the family room sofa, was the first victim. He was beaten by Farrell in the head multiple times with a crowbar. His injuries were so extensive with the wounds to the head, some of which fractured his skull, was leading to his death. He also had multiple chest wounds, which fractured his ribs on the right side. After Richard Wendorf's death, Noah McQueen came from the bathroom to the kitchen area of the home when she was confronted by Farrell. Farrell had just blood on his clothes from her husband from her husband's beating and carried the, I keep getting these little things that pop up, they gotta quit, and carried the crowbar in his hands. Miss Queen spilled out her hot coffee on him, scratched his face, and fought him until she was beaten to the floor and was then beaten in the head multiple times. After the murders, Farrell and Anderson searched the house for valuables, money, and keys. A Discover card was found and taken from the body of Richard Windroff. Farrell and Anderson then left the house, and the Windroffs explored with the car. Farrell and Anderson. Okay, so then they met Cooper Easy's and Heather Windroff in the Buick Skyhawk. As the girls were returning to the area of the Windroff's home, the entire group then left Eustis. So these three girls, including these people's daughter, got in the vehicle with these two guys, and then they left Florida and went over to Louisiana. Because of the telephone call made in Baton Rouge, Louisiana, to one of Charity Kesey's relatives, a BOLO was issued and all 5 subjects were apprehended. There followed 2 videotaped statements from Farrell reconstructing slightly different versions of the crimes to Baton Rouge Police Sergeant Ben Odom and later to Lake County Sheriff's deputies Al Guzzler and Sergeant Wayne Lango. In these statements, Farrell recounts in detail surveying the home, entering the garage and choosing a weapon, entering the home, disabling a telephone, committing the murders of both victims, and taking property and the vehicle from their home. Shannon Yohe testified that on Monday, November 25, 1996, Farrell and 3 others showed up at her home asking to use the telephone. Farrell got directions to the residence from Heather and recorded those directions on a handwritten map. Shortly thereafter, the following conversation took place as described by Mrs. Yohe. Okay, when we're sitting there and Rod started saying that he was going to go steal the Windroff's car, and because his car wasn't working right, like I said before, he said that he wanted to go kill her parents, and I asked him why. He said because he just wanted their car. Under the settled Florida laws, the cold, calculated, and premeditated aggravator was of the 4 elements. A murder that was the product of a cool and calm reflection and not the act prompted by emotional frenzy, panic, or fit. The murder was the product of a careful plan, a prearranged design to commit the murder before the fatal incident. Number 3, there was premeditation over and above that required for unaggravated first-degree murder. And number 4, there is no pretense of moral or legal justification. And then it gives a couple other cases where this was used. The pretense of moral or legal justification is any colorable claim used by at least partly on uncontroverted and believable factual evidence or testimony that, but for its incompleteness, would constitute an excuse, justification, or defense as to the homicides. It gives a few cases where that was used. Colorable means that which is in the appearance only, having the appearance of truth. Black's Law Dictionary, 265, blah, blah. Appearance means that there must be at least some basis in fact to support the defendant's belief that the killing would be excusable, justifiable, or subject to a legal defense. Of course, we are not dealing here with delusional defendants, as in Santos, whose internal distortion of reality more properly is relevant to the coldness of the elements. We talked about Wall versus State. When those criteria are applied to the facts of this case, the cold, calculated, and premeditated aggravator is established beyond a reasonable doubt. Based upon the testimony of Shannon Yohe, there is no doubt that the murders in this case were the product of cool, calm, and reflection. Farrell stated that he was going to kill the victims because he wanted their car. The statement was made well before the murders occurred, and there is nothing to support Farrell's self-serving claim. See, another one just popped up. As a frenzied attack. Farrell's discussions committing 2 murders in calm, dispassionate manner several hours before he carried the plan out. The first part of the cold, calculated, and premeditated aggravator is well established. Likewise, the second and third prongs of this aggravator were proven beyond a reasonable doubt. The evidence clearly established that Farrell's surveillance of the Windroff home before entering through an unlocked door produced a weapon from the garage which was preferable to the one that he had brought with him. Silently entered the home, and upon finding Mr. Windroff asleep on the couch, proceeded to beat him to death in accordance with his plan. When confronted by Mrs. Queen, Farrell followed the plan and beat her to death as well, but he was somewhat hampered by her unexpectedly strong resistance. Moreover, The heightened premeditation component exists because, beyond a reasonable doubt, it was well established by the evidence that Farrell was discussing his plan to kill his victims to obtain their car well before the plan was executed. This degree of planning and ruthlessness is more than sufficient to establish the third component of the cold, calculated, and premeditated aggravating circumstances. Finally, there is no culpable claim that the two murders were committed for any reason other than to obtain a vehicle, their victim's car, while Farrell claims that the murders were committed so that Heather Wendroff could escape to a better life. Those self-serving statements are contradicted by the unequivocal statement to Shannon Yohe that he intended to kill his victims because he needed their car. Each component of this cold, calculated, and premeditated aggravator has been established beyond a reasonable doubt. There is no basis for Farrell's self-serving claims, and competent substantial evidence supports this aggravator. The terms heinous, atrocious, and crucial aggravators. On pages 74 through 79 of his brief, Farrell argues that the heinous, atrocious, cruel, aggravating circumstances, which was found to be one of his two murders, was improperly found because, according to Farrell, the evidence does not support it. This claim is not a basis for relief for the reasons set out below. In finding the heinous, atrocious, or cruel aggravator, the sentencing court has made the following findings. The circumstances is clearly proved by the facts recited above and beyond a reasonable doubt. When Farrell confronted Nona Queens, his clothes were bloody and stained from her husband's beating, and Farrell had the crowbar in his hands. Mrs. Queen spilled hot coffee on him, scratching his face, and fought him until she was beaten to the floor as well. And then had multiple times. It is clear from the... go back. Oh, boy. Go back. Lost my little thing here. Oh, boy. So it is clear from the defensive wounds on her hands and arms, as well as Farrell's own description of the event, that Mrs. Queen was faced with an unspeakable fear and terror as she faced and fought her murderer. These facts support finding a heinous, atrocious, and cruel, and the citations omitted. The circumstances is given great weight by the court, as it shows Farrell's complete indifference to and enjoyment of the suffering of Mrs. Queen. Absolutely. Absolutely. Those findings have ample... Hang on. No, it's not beer. It's Dublin vanilla cream soda. It's delicious. Okay. Those findings have ample support in the record. The medical examiner who conducted the autopsy of Mrs. Queen identified 21 separate identifiable wounds. A number of those wounds were to Mrs. Queen's head, but she also sustained a number of defensive wounds, which indicate that she was conscious when those wounds were inflicted on her. Farrell argues that he did not intend for the murder of Mrs. Queen to be consensuous or pitiless, and therefore the heinous, atrocious, or cruel aggravator cannot apply. The claim is foreclosed by clear precedents. The court has stated, although Mann claims he did not deliberately inflict pain and thought that the initial stabbing, okay, this is some other case that tried to use the same excuse as to get a new trial. So, blah, blah, blah. Let's go back over here. The testimony supports the state's theory that many, if not all, oh, no, don't go to TikTok. Oh, my gosh. His testimony supports the theory that if many, not all of the injuries were inflicted before a blow to the head caused unconsciousness and eventually death. We believe the evidence is broad enough that the prior of facts could reasonably infer that the victim was conscious during this. You know what? They're describing a different. This is the case about Mann versus State that they're describing. I'm not going to read all that because it's just saying, hey, in this case, y'all chose to use blah, blah, blah. So we're not going to talk about that one because it's just a big, long bunch of different cases that they're trying to throw in there as the reason for their brief, right? To the extent of further discussion of the intent of element of the heinous, atrocious, and cruel aggravator is necessary that this court squarely reject the claim Guzman versus State. This court held, and it talks about Guzman, so we're not going to read all that. Okay. In a remarkably misleading bit of appellate advocacy, Farrell seems to argue that because Mrs. Queen, the took the offensive with preemptive strikes of scalding hot coffee, her murder was not unnecessarily torturous and therefore was not heinous or atrocious or cruel. No rule of law known to counsel the state suggests or implies that resistance by a murder victim somehow removes a murderer from eligibility for the heinous, atrocious, or cruel aggravator. This claim is frivolous and has no basis in law for a reason or has no basis for reversal of Farrell's death sentence. The heinous, atrocious, or cruel aggravator is supported by competent and substantial evidence. Oh my gosh, quit it. And Farrell's sentences of death should not be disturbed. Death in the proper sentence. On pages 80 through 84 of his brief, Farrell argues that the beating murders of the two people during the burglary in order to gain possession of their vehicles does not represent a case in which death is the proper sentence. Farrell claims it's based upon two theories, neither of which has any factual or legal basis. Farrell's first claim is that the cold, calculated, and premeditated and heinous, atrocious, or cruel aggravator were improperly found. For the reasons set out above, both of those aggravators were shown to exist beyond a reasonable doubt by competent, substantial evidence. Because that is so, Farrell's argument is based upon a faulty premises that this case is heavily aggravated and is not sort of the case for which death is proper penalty. Farrell's complaints concerning the weight given to these various aggravators are no more than his dissatisfaction over having received the sentence he deserves. The weight given an aggravator in the province of the sentencing court. Farrell's failure to see why certain aggravators were given the weight that they were is not a valid complaint. The second component of Farrell's proportionality claim is his argument that mitigation was not given enough weight. Once again, the weight given to the mitigating evidence is within the province of the sentencing court, and the fact that Farrell does not like the result is meaningless. And it goes about Cole versus State and talks about some other cases where this, again, the person did not like the sentence they were given, so they just filed a brief to try to get in trial. Farrell presented testimony and evidence in this case in an attempt to establish both statutory and non-statutory mitigating circumstances. In particular, the defense presented the videotape recording of Farrell making his quality plea to the court and the testimony of 3 mental health experts and witnesses of 19 other witnesses. Notwithstanding the evidence, the jury unanimously returned advisory recommendations for the 2 death sentences. The defense argued to the jury that in this case that it should find and give significant weight to 3 statutory mitigating circumstances and 21 non-statutory mitigating circumstances. These mitigating circumstances or mitigators were actually listed in numbered fashion for the jury by defense counsel during her closing argument. In this case, each of these mitigators is discussed below. Many of these mitigating circumstances are similar to the ones to another or otherwise overlap each other. Under settled Florida law, a mitigating circumstance is broadly defined as being a fact that somehow reduces the defendant's degree of culpability for the murder he stands convicted of. And there's a few cases where it talks about that. It must be considered if it is truly mitigated, but the weight given of a particular mitigator is within the province of the sentencing court. There's a few cases where they talk about that. A defendant is not entitled to relief merely because he is not satisfied with the weight given on certain offered mitigators. Okay? The sentence order in this case is highly detailed and devoted some 12 single-spaced pages to discussion of the various proffered mitigators. That order makes clear the existence of the facts offered in the mitigation and the mitigating effect of those facts are 2 different matters. While various mitigators tend to evoke sympathy for the defendant, the aggravators that were proven beyond a reasonable doubt outweigh the mitigation. Of course, the weighing of the aggravators and the mitigators is not simply a counting process. The sentencing court undertook a careful analysis of the sentencing factors and found that the aggravating circumstances outweighed the mitigation. That finding is supported by competent, substantial evidence and should not be disturbed. Death is the proper sentence. Farrell's age as a bar to execution. Okay, so now they're going to come back and talk about his age because he was 16 at the time that this happened. So when he first was tried, they could be given the death penalty at the age of 16. because he was tried as an adult. Okay. On pages 85 through 94 of his initial brief, and in his supplemental brief, Farrell argues that because he was 16 years old and 8 months, he had planned and carried out the burglary, robbing, and beating deaths of 2 people in order to obtain their vehicle. He should not be executed for those murders, citing to this court that as of July 8, 1999, the decision in Brennan v. State, he gives his numbers, Farrell asserts that the law compels a reduction of his sentence of death to sentence of life without parole. Brennan was wrongly decided and should be overruled. Farrell has not sufficiently briefed this issue in his 3-page supplemental brief, which does not comply with the spirit of this court's order for supplemental briefing. Instead, Farrell has violated the court's well-settled rule in that, in any event, it is clearly not proper for counsel to attempt to cross-reference issues from a brief in a distinct case pending in the same court. The law is well settled that the failure to raise an available issue constitutes an admission that no error occurred. Moreover, we do not believe it is wise to put an appellate court or opposing counsel in the position of guessing which arguments counsel deems relevant to which of the separate cases. Nor do we support a rule that might encourage counsel to brief the court through a simple incorporation by reference. Accordingly, all available issues not raised in the present briefs are barred. In Johnson v. State, gives all the different numbers. That's not right. Farrell's supplemental brief does not comply with the settled Florida law. In Brennan's decision, this court relied on Allen v. State, gives all the numbers, for the propositions that the defendant, who was 16 at the time of committing a death-eligible murder or murders, as in Farrell's case, cannot be executed as a matter of law. Brennan exploited that Allen's decision to apply 16-year-old murderers, even though Allen did not, by its plain terms, decide the death eligibility of this group of killers. Moreover, while this court stated from Brennan that it did not base Allen on the United States Supreme Court case law, the fact is that Allen reached the same result as Thompson versus Oklahoma, and it gives a bunch of different numbers. So, it's withheld that the defendant, who was 15 at the time of the crime, could not constitutionally be executed. Under Article 1, Section 17 of the Florida Constitution, as amended on November 3, 1998, the cruel and unusual provision of the state constitution must be interpreted in conformity with the United States Supreme Court precedent. Oh my gosh, I'm getting thing after thing that just keeps popping up. Let's just stop. Okay. Under such precedent, it is not cruel or unusual to impose a sentence of death on a defendant who was 16 years old at the time of the murder, giving rise to the sentence of death. This court should do as it's required to do under the Florida Constitution and follow federal constitutional precedent on the issue, Stanford versus Kentucky. In the Brennan decision, this court made much of the fact that these 16-year-old killers are sentenced to death, and that of the recent defendants falling into that category, all 3 have had their sentences vacated. That gives Brennan versus this person. While that statement is true, as far as it goes, the court did not recognize that Jeffrey Fairness has been sentenced to death by a Volusia County jury. And moreover, Farrell's appeal was pending when this court decided on Brennan. Obviously, the advisory juries in this case and in the Farina case believed that death was the proper punishment, despite the age of the defendant at the time of the crimes. The age of the defendants was given effect as mitigation, which is of the proper place for such consideration. That does not render the imposition of the sentence of death unconstitutional when a 16-year-old commits a first-degree murder that is eligible for sentence of death. And it is heavily aggravated and unmitigated that a death sentence withstands proportionality review. Farrell's death sentence should not be disturbed. It says see Lamb versus State law. On October 21, 1999, this court issued a revised opinion in Brennan versus State, which reached the same results as the original opinion. The death sentence was reduced to sentencing of life without parole. However, the revised Brennan opinion did not address the specific issues of the November 1998 amendment of Article 1, Section 17 of the Florida Constitution and the applicability of the amendment to Brennan's case. On November 3rd, 1998, Article 1, Section 17 of the Florida Constitution was modified to read the following. Excessive fines, cruel and unusual punishment, attainder forfeiture of estate, indefinite imprisonment, and unreasonable detention of witnesses are forbidden. The death penalty is an unauthorized punishment for capital crimes designated by the legislature. The prohibition against the cruel and unusual punishment and the prohibition against the cruel and unusual punishment shall be construed in confronting with the decisions of the United States Supreme Court, which interprets the prohibition against cruel and unusual punishment provided in the 8th Amendment to the United States Constitution. Any method of execution shall be allowed unless prohibited by the United States Constitution. Methods of execution may be designated by the legislature, and a change in any method of execution may be applied retroactively. A sentence of death shall not be reduced on the basis that the method of the execution is invalid, in any case in which an execution method is forced until the sentence can be lawfully executed by any valid method. This section shall apply retroactively. Okay, this means that whatever method that the state is currently using is the method they'll be using. So if they were sentenced to death, and when it was first happening, it was by lethal injection, but then they decided they were going to do a firing squad. Well, it didn't matter that it was lethal injection back then. He would get the firing squad instead, which is pretty horrible, I know. So, based upon the clear language of the state constitution, this court is required to construe the state constitutional prohibition against cruel and unusual punishment in conformance with the United States Supreme Court's construction and interpretation of the 8th Amendment of the Constitution of the United States. However, the Brennan opinion did not follow the state constitution and instead held that Stanford versus Kentucky was not binding in our state's constitutional analysis, even though the United States Supreme Court had held in the case that it was not unconstitutional to impose a sentence of death on an individual who was 16 years old at the time of the offense. Under the plain language of November 1998 amendment to Article 1:17, Stanford is clearly binding on this court's analysis of the constitutional claim. Under the settled law, Farrell's claim is meritless because a sentence of death can constitutionally be imposed on him. To the extent that Farrell may argue that there is some deficiency with the conformity clause, the amendment to Article 1:17 Florida law is clear that such amendments are valid. Such conformity clause amendment to Article 1, Section 12 of the Florida Constitution was approved in 1982, which required that the state constitutional rights to freedom from unreasonable searches and seizures shall be construed in conformity with the 4th Amendment of the United States Constitution. This court has repeatedly acknowledged that the Conformity Clause Amendment absolutely binds the court to follow the interpretations of the United States Supreme Court with regard to the Florida Amendment. This court has held that the 1982 Amendment to Article 1, Section 12 is prospective only in application because the amendment did not provide retroactive applications. State versus somebody else and all the little numbers that go with it, blah, blah. Such reasoning does not apply to the Article 1, Section 17 Amendment because in 1998, the amendment expressly provides that the provision is retroactive in its application. To the extent that the Brennan majority questions whether application of the amendment to Article 1:17 would be a violation of the ex post facto prohibition contained in the United States Constitution because it is adversely affected in the substantive law in effect at the time of the original crime. The substantive law at the time of Farrell's crime did not make him ineligible to receive the death sentence. Under any view of the law, at this time, Farrell's crime, and at the time he was sentenced to death, no decision by this court precluded such a sentence, and moreover, United States Supreme Court precedents established that such a sentence was constitutional. Farrell was eligible under both the United States and Florida Constitution for a death sentence at the time he committed 2 murders, and was likewise eligible for such a sentence under the law in effect when he was sentenced to death. Because this is true, The Conformity Clause Amendment to Article 117 did not affect the substantive law in effect at the time of the crime. Under such law, death was an available sentence. That sentence should not be disturbed. Based upon plain language of the article, the Florida Constitution, this court is clearly required to follow the United States Supreme Court's decision concerning the construction of the state's federal protections from cruel and unusual punishment. There is no doubt that Standard versus Kentucky is a decision of the United States Supreme Court, which rejected a claim that it violates the Eighth Amendment to the United States Constitution to impose sentence of death on an defendant who was 16 years old when he committed capital offenses. Those two fundamental propositions are not open to debate. And because that is so, the only conclusion possible is that the federal sentence of death should not be disturbed. I think I'm on page 74. So we are going to be able to finish this today. Yay! Then we'll get back to Aubrey Trail tomorrow. And there's some other ones I want to talk about who also claimed that they were either killing zombies, or they were witches, or they were vampires. There are so many of these that I had no idea until I started researching. I was like, Lord, look at all of these. This goes all the way back to the 1600s. I found cases from the 1600s where they claimed, oh, well, they were witches, or oh, well, they were vampires, or that they were slaying zombies when they killed people. It's that amazing, guys. It's that amazing. While it may be true that no modern execution has been carried out in a case in which the defendant was under 17 at the time of the crime, that is the only half of the analysis which standing alone establishes nothing about the existence of any consensus regarding the death eligibility of a juvenile defendant. The relatively small number of 16-year-old capital defendants is most likely explained by the relatively small number of first-degree murders committed by such individuals, rather by any reluctance to impose the death sentence on such individuals. The most that any infrequency of the death sentences for 16-year-old defendants indicates, assuming a number of prosecutions that resulted in first-degree murder convictions but no death sentences, is that the age being given effect is a mitigator, and that Florida sentences are following the law, reserving the death penalty for the most aggravating and at least mitigated of murders. While it may be unusual for 16-year-olds to receive a death sentence, it is even more unusual for 16-year-olds to commit such a crime in the first place. This does not render the imposition of sentence of death unconstitutional in the circumstances when the 16-year-old commits a first-degree murder who is eligible for a sentence of death, and which is also heavily aggravated and unmitigated that it withstands proportionality review. Farrell's case falls with that category, and his sentence of death should not be disturbed. This is the state's cross appeal. The trial court erroneously refused to find the avoiding arrest an aggravator. In the final sentencing order, the sentencing court found that avoiding arrest aggravating circumstances was not proven. The sentencing court should have found the existence of an aggravator because the dominant motive for the murders was the elimination of a witness, which is the standard for application of this aggravator to the murder of non-law enforcement witnesses. And it gives them, other cases where this has been done. The evidence, which was in the form of a statement by Farrell that was taking out of killing the victims, was discussed by Farrell and Anderson before they entered the Wendorf residence. The term unusual is not used here in the constitutional sense. Farrell stated, we decided at that point before, because I pulled Scott to the side, because I got to thinking about how Heather's parents would probably react. I didn't want to be, moreover, the evidence was, and I don't know what that's got to do with it, because it leaves like it just says unusual, and it gives a little snippet of what he said at that time about Heather's parents. That's on page 74. Moreover, the evidence was that Farrell obtained a more lethal weapon from the Wendorf's garage before he entered their home. He beat them to death and took the Ford Explorer that he had set out to obtain. Based upon the evidence supporting the aggravators, it is clear beyond a reasonable doubt that the two victims were beaten to death to eliminate the only two witnesses to their theft of their vehicle, thereby delaying the discovery of the crime and making an undetected escape much easier. The primary motivation for the murder of the two people was the furtherance of Farrell's goal of escaping detection. This aggravator should have been found by the sentencing court, and moreover, should receive great weight in the weighing of aggravators and mitigators. You can see these different cases where they used this before. This court should correct that error of law. and apply the witness elimination aggravator. The exclusion of testimony. All right. The trial court also prevented the state from presenting the, talks about some other things. It goes, Farrell had discussed killing the victims on other prior occasions. So it wasn't the first time that he had talked to these other people about killing these parents. This has something to do with the daughter that was in his group. Now, I don't know if he was dating her. It seems to me like maybe he was dating her. I'm not sure. But, this was a plan that he had talked about many times before. This was not just something he decided to do that day. This goal was successful and evidenced by the fact that Farrell was not taken into custody until several days later, and by the fact that the only reason he was located in Baton Rouge, Louisiana, was by virtue of a tip to law enforcement from a family member of one of Farrell's companions. But for that tip, Farrell would not, at that least, have been apprehended as quickly as he was. Testimony of Aubrey Presence that Farrell had left the state of Kentucky because he was running from the law, because they had found him building bombs. He's pretty bad, wasn't he? This testimony was improperly excluded by the trial court because it was relevant to the avoiding of arrest aggravator. Specifically, the testimony was relevant, as the state argued below, because the evidence was that the vehicle in which Farrell was traveling kept breaking down, and he needed another vehicle to continue his flight to Louisiana. As such, the relevance of this evidence was that it supports the avoiding arrest aggravator by explaining Farrell's motivation for avoiding capture, as well as fleshing out the motive of the theft of the Winders vehicle. Of course, because the evidence was offered at the penalty phase on Farrell's capital trial, relevancy was the standard for the admission and gives the numbers under 921 blah blah. Because the evidence was relevant, it should have been admitted. Okay, and then it goes, in conclusion, for these reasons set out above, Farrell's sentence of death should be affirmed in the following aspects. Blah, 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 and it was signed and recorded. Okay, so that was all 78 pages of the brief. Whoa! Okay, so we learned a lot about little Mr. Rod Farrell here today, haven't we? We sure have. And he's just one of the ones out of the many that I have found that either claim to be a witch, a slayer of zombies, or a vampire. So, I've been on for like 2 hours and 6 minutes. Ooh, that's way too long. Anyway, let me look at something else. Go back over here, guys. Hang on. So that is just one more of these people. I mean, these people go all the way back to, like I said, the 1600s or so. Hang on. There's many of them. Whoops, hang on a minute, guys. Oh, my dog's over there just snoring, poor little guy. I guess he was tired. Okay. So I want you to listen to this really quick, and then I'll let you go. While most figures like Vlad the Impaler and Elizabeth Bardi are considered monstrous historical figures rather than literal vampires or witches, there are documented cases of real serial killers who were influenced by or obsessed by vampires and witchcraft. Okay. Richard Chase, the Vampire of Sacramento. This is another one. We'll get to his things too. Richard Case was diagnosed as paranoid schizophrenic who believed that the Nazis were turning his blood into powder and that he needed to consume fresh blood to survive. His crimes in 1977 and 1978, Chase embarked on a killing spree in California, brutally murdering 6 people. He broke into homes, engaged in necrophilia, cannibalism, and the drinking of their blood. Nicknamed, his fixation with blood led the staff at the mental institution to call him Dracula before the murders began. And then we talked about Rod Farrell and the Vampire Clan. We just read his brief. And we talked about Tracy Wigington, the lesbian vampire killer. Okay. Then there's also Michael and Susan Carson, the San Francisco witch killers. Okay. Michael and Susan Carson were married a couple who went on a murder spree in the early 1980s, driven by some bizarre delusions. Crimes. They killed people who they claimed to have on a hit list of others, including celebrities and politicians, who they believed were witches. So they were taking out the witches, right? They didn't claim to be witches. They were taking them out, all right? They killed 3 people and claimed to have a hit list of others. The couple also held paranoid anti-government beliefs, which they mixed with their religious extremes, but they were both sentenced to 75 years to life. There's also Peter Stump, the werewolf of Bedburg. While technically a medieval legend, The tale of Peter Stump is often cited as a historical case of supposed serial killer linked to the supernatural. Accusations. In 1589, the German farmer was accused of being a serial killer, a werewolf, and a cannibal. He was tortured into confessing to the gruesome murders over a dozen people, including his own son. His execution. Stump was executed in horrific fashion along with his alleged accomplices as a part of a sensationalized witchcraft trial. Donald Hurting Sr. Donald Hurting was convicted of murdering his family in Florida, with investigators pointing to possible occult influences. In 2006, Hurting murdered his mother and her wife in an act authorities suspected may have been a ritual sacrifice. He was convicted of these murders in 2022. The ritual speculation was the belief that the killings were witchcraft related and spread fear through the local community. Though the prosecution did not ultimately prove a ritual sacrifice. And then it talks about Rod Farrell. That was the other ones. So, I mean, there's several notorious serial killers and cult leaders that have used themes of vampires or witches to justify their crimes. This is often tied to delusions, cult beliefs, and the desire to control and manipulate others. Chad Daybell, here you go. This is you. So we've got Rod Farrell. We've got Richard Chase. We've got Tracy Wigington. We've got Elizabeth Bathory. We've got Adolfo Constanzo. Okay? Adolfo Constanzo, a Cuban-American occult leader, combines Santeria Palo Mayombe Aztec warrior rituals in his practice of witchcraft. In the late 1980s, he and his followers, known as the Narco-Satanistas, I don't think I'm saying this right, the Narco-Satanists were responsible for numerous realistic murders in Mexico. Costanza used human sacrifices, often drug dealers and rivals, to create a magical shield for his drug trafficking operation. Followers referred to him as the Godfather and his female accomplice, Sarah Alderete, as the Godmother. Then we got Walpurga Hosman. I know I'm not saying this right. Walpurga Hosman was a 16th century widow executed for her witchcraft in Germany. She confessed to killing a numerous amount of infants and drinking their blood, leading to speculation that she was both a witch and a serial killer. Okay, and the modern vampire cults, besides Rod Farrell, well, tell me. Let's see. Show all of them. Okay, we've got Rod, we've got Adolfo, we've got Sarah, we've got Tracy, the Kentucky Vampires. We've got how about this one? At Rancho Santa Elena, March 4th, 1989. There we go. Let's read about this one for a second. And now I'm going to save this one for tomorrow. So I'm going to let y'all go for today. I mean, it's quite interesting. Another thing I'm going to talk about, besides what I'm going to talk about with my when Sprinkle Donut comes on with me, is I'm going to do a little segment on witchcraft or witches and the Bible. I mean, there's a lot of talk about this, and it's very controversial, and I know that. I know anything about religion is very controversial. But, let me see what it says. Hang on, I got a message. I got to check it here. Let me see. All right, so I'll talk to her in a little bit. Anyway, so we're going to talk about that later. Anyway, you all have a good afternoon. I hope you enjoyed what you've heard today. If you haven't, that's okay too. I know my channel's not for everybody, and that's okay too. Anyway, see you later. Have a good day. Bye, guys. Bye. Peace out.